It's a great pleasure for the F.W. de Klerk Foundation to welcome today Advocate Paul Hoffman, who is the head of Accountability Now. Paul has been a constant fighter for constitutional rights and accountability since I can remember. And I think that since I can remember, he has also always been very concerned about the inability of the judicial system to deal with what have appeared to be clear breaches of judicial codes by Judge Hlophe, the Judge President of the Western Cape. Paul, can you just give us an overview of the complaints against John Hlophe? Why is the legal profession concerned? Why finally and ultimately in April this year did the JSE recommend that he should be impeached? And how is it that the same JSE decided a few weeks ago not to request the president to suspend him after having found him to be an improper person to carry out a judicial function? Can you explain this to us?
It's totally inexplicable and unaccountable behavior, but let me try and give the elephant a bite-sized response. The first question you asked was really most easily divided into past, present, and future disciplinary proceedings against our judge president in the Western Cape. The past disciplinary proceedings ended very unsatisfactorily. They concerned his racism. They concerned his preparedness to moonlight for the Oasis group, and they concerned a particularly difficult incident with a young attorney who he called a piece of white shit and invited to return to Holland, although the young man had never been to Holland in his life. All of those, including a tax evasion charge, were just swept under the carpet by a committee of the Judicial Service Commission, and he sailed on to badger two of the judges in the Constitutional Court to fine for Jacob Zuma in pending litigation there. That is the present complaint, which is the subject matter of the adverse finding of a judicial conduct tribunal, which he is now taking on review on the basis that the finding against him was not made by a properly constituted body, using a decision that Helen Ziller won when she was left out at an earlier stage in the same proceedings. And then there are the future proceedings against him, which have to do with the unhappy relations within his division, the schism between him and his deputy, the allegations that he has beaten up one of his junior judges, and who is on suspension, by the way, and has been involved in less than savory interaction with his wife and his deputy, the truth of which is only ever going to emerge when they are, all three of them are subjected to cross-examination on his alleged misconduct. The litany of complaints against him is so overwhelmingly large that one would have thought that had he a modicum of self-respect, that he would have fallen on his sword many years ago. Instead, he made the latest sitting of the Judicial Service Commission into a circus, hijacking the proceedings in order to complain about white silks who insist that black judges are not up to the task of hearing cases allocated to them by the self-same judge president, and what is to be done about this particular allegation. Now, whether or not it is true that that is what happens, one would think that if litigants choose to go to arbitration rather than to take their chances in litigation before the High Court. That would be a good thing in that it reduces the burden on the taxpayer to pay for that litigation and gives work to arbitrators who are paid by the litigants rather than by the taxpayer. But that doesn't seem to have crossed Judge President Hlophe's radar. It is actually a huge problem as far as the Judicial Service Commission is concerned, that it has allowed the present complaint to drag on from 2008, when it was first laid, May 2008, to the present time without any sign of the matter reaching finality. The president is also in a position, in his discretion, to act or not act on a recommendation. And if he chooses, he may, in his discretion, suspend a judge who is under a cloud of suspicion, whether or not the Judicial Service Commission so recommends. He's not bound by their recommendation. So the president himself has allowed himself to be sucked in to the spiral of deceit and dishonesty and bad behavior generally that has as at its center Mr. Justice John Hlophe.
Now, but Judge Hlophe has appealed against the decision of the Judicial Service Commission earlier this year. How long could this process take? And if he's not suspended, how long will he remain in the key position as president of the judiciary in the Western Cape? And what implications does this have for the credibility of the judiciary, not only in the Western Cape, but also in the country? How can it be that somebody who has been found guilty of a serious crime with many, many other serious allegations against him can continue to play this pivotal role in our judicial system?
Well, you see, Judge Hlophe happens to be the first Black judge president elevated to that rank in the New South Africa. And the suspicion is that he is regarded as a royal game because it would be a sad day for the transformation of the judiciary in South Africa if the first Black judge president finds himself on the receiving end of appropriate disciplinary action against him. There's not an appeal pending at the moment, it's actually a review. And the review is brought in the High Court. And if the review is unsuccessful, or the outcome of the review is unsatisfactory to either party, which is likely to be the case because it's a hard-fought battle, then the outcome of the review can be taken on appeal to the Supreme Court of Appeal, and from there to the Constitutional Court. Now, my understanding of the position is that Judge Hlophe is eligible to retire on a full judge's salary when he reaches his 65th birthday, which is in May 2025. So when you ask how long is he going to be there, it's almost a racing certainty that if the lackadaisical approach of the JSC and the ever so slow approach of the courts is persisted in, that he will reach retirement age before the litigation concerning his impeachment or possible impeachment ever gets to fruition. And bear in mind that if he is able to persuade more than 1/3 of the members of the National Assembly that he is a fit and proper person to continue as judge president, should they ever be put to that vote before then, the instructions given by Lutuli House in regard to what his fate should be could play a pivotal role in whether or not the impeachment succeeds at all.
And now, one of the earlier complaints against Judge Hlophe related to the Oasis matter, where it appears that he was receiving payment from Oasis while at the same time adjudicating in a case that dealt with Oasis's interests. I mean, I would have thought that this was one of the most basic elements in the whole process of being a judge, of not having an interest in the case in which you're adjudicating. How did this happen?
Well, what in effect happened was that his deputy was not prepared to give Oasis permission to sue a judge. There was a dispute between leading figures in the Oasis group and Judge Siraj Desai. And the Oasis people wanted to sue Judge Desai for defamation, and that you cannot do without the permission of the judge president. And when the deputy, well, I think he was away, or he may even have said, I don't believe I should make this decision. But when he was away, Jeanette Traverso, the deputy judge president, declined to give permission to sue. And on his return, he overruled her and gave permission to sue in circumstances in which, as you suggest in your question, there was a clear conflict of interest because he was on the payroll at Oasis and ought not to have given that permission. But this seems to have been simply swept under the carpet in a hearing of the Judicial Service Commission disciplinary body, as it was at the time.
Now, Paul, what does this mean for the whole idea of accountability in South Africa? If one of our top judicial officers cannot be held accountable even after he's been found guilty of gross misconduct, continues on in his job as though nothing has happened, what does that say about the whole idea of accountability and the requirement in Section 1 of our Constitution for a democracy that is open, accountable, and responsive?
Yes, certainly the system of governance is, as a foundational value, supposed to be accountable. But the answer to the question that you will get from those who support Judge Hlophe, and remember, he is a candidate for the Chief Justice, as you and I sit here now, because the Black Lawyers Association has nominated him as a candidate for Chief Justice. So they are building upon the innocent until proven guilty theme, a principle that applies to those who are in the dock facing criminal charges, not to those who are in positions of authority in society, leading a very busy and large division of the High Court, and really responsible for the proper administration of justice in an impartial and independent way. That is not happening in the Western Cape High Court. There is a great deal of misery in the Western Cape High Court because Justice Hlophe has turned it into his personal fiefdom. He repeatedly appoints acting judges who are just cronies of his, and he makes life miserable for those of the judges who've been prepared to put their head above the parapet and to call him out on his mendacious and deceitful behavior. That problem that we have is because our courts are not managed as they should be, and a matter of such great public interest and moment is not given accelerated hearing on the court rolls. It's very clear that the proper administration of justice, the principle of accountability, is being rubbished by the way that Hlophe has dealt with his various disciplinary problems, and that will continue for so long as the courts continue, the courts and the Judicial Service Commission, which is not just judges, as long as they conspire to continue to keep this entire circus on the long road to nowhere, rather than being brought to a head rapidly, we are going to have to continue to put up with what is a most unsatisfactory position from the point of view of the rule of law, the proper administration of justice, and the continuation of impartial and independent hearings in our courts. It really is a very serious problem. The fact that the Black Lawyers Association has been so ill-advised as to nominate Judge Hlophe as its nominee for the Chief Justiceship tells you how far the Black Lawyers Association, and with it South Africa, have strayed from the path of the rule of law.
Well, what does this mean for parties that are going to appear before Judge Hlophe in future litigation? Won't they be able to say, but wait a second, we're not going to accept the judgment of this judge because he's been found to be an unfit and improper person by the Judicial Services Commission? Won't they have a case to appoint an ability to appeal against anything he does?
The good news for litigants in the Western Cape High Court is that Judge Hlophe much prefers the administrative aspects of his work rather than the judicial aspects. And he very seldom graces the bench as a sitting judge. If one looks at the record of his reported cases, then you will see that unlike his predecessors, he has not involved himself unduly in adjudicating disputes that are brought to his court. He prefers to allocate the adjudication of disputes to others. Those in civil litigation who do not even trust his ability to allocate in a manner that is unquestionable have the option of taking their dispute away to arbitration, which is often done and is really the subject matter of his complaint, that black judges are avoided by some litigants who instruct their lawyers to postpone, kick for touch, or divert to arbitration rather than take their chances with the judge that is allocated by him. But he has a very powerful position as the judge president, because as judge president, he is in charge of allocating cases. One of the complaints about him emanating from his deputy is that he tried to steer the review proceedings concerning the crooked nuclear power deal that Jacob Zuma had done with the Russians to two judges who were favorably disposed towards Jacob Zuma and his administration. And it was only by her intervention that the matter was given to the judges who heard the case and, in fact, ruled that the Rosatom matter was invalid and should be struck down as such. Otherwise, we would be sitting today, if Hlophe had got his way, we could be sitting today with a situation in which we basically commit our fiscus to an act of insolvency with the Russian nuclear suppliers.
Well, then finally, you mentioned that Judge Hlophe has been nominated now for the top position, Chief Justice. Would you like to say a few words about the selection process for I think the 8 candidates, and what the prospects are for the process in the coming weeks? When will a new Chief Justice be chosen, and what do you think about the selection process?
Yes, I think that what the president has done by seeking to make the process one that involves public participation is basically to devalue the coin of the realm. The people who know how to, or who should be the next Chief Justice, are those involved in the practice of law, not in civil society generally, or in the business community, and certainly not in the political community. So this process of opening the selection of the Chief Justice to public participation has thrown up some really weird and wonderful nominees. And because the process worked on the basis that really a tick list of administrative requirements with which Judith February has dealt in her Judith Prudence column in the Daily Maverick today, the 14th of October, because it was simply an administrative tick list. Basically, anybody who was appropriately qualified, had accepted the nomination, had the nomination seconded and approved by a constituency of some sort, got onto the list. And in effect, there are only 4 serious candidates. Hell will freeze over before John Hlophe becomes Chief Justice. I say that because it is not really possible that any country in which the rule of law and the Constitution embodying impartiality and independence of judges would allow him to become Chief Justice. So there are 4 serious candidates. They are Judge President Meyer of the Supreme Court of Appeal, who, if elected, would become the first woman to be Chief Justice in South Africa, and that would probably appeal to the president, as he would then be breaking some new ground and go down in history as the first president to appoint a female Chief Justice. She is certainly up to the task. A second judge president who is on the short list of 4, the serious contenders, is Dunstan Malambo, who has led the Gauteng court very ably for a very long time. And he would be able to grace the Chief Justice's office with a much more aplomb than his predecessor, mainly because he will not have a biblical soapbox in the office with him. The third contender is Justice Zondo, who is our acting Chief Justice at the moment and was Deputy Chief Justice until the retirement of Mogoeng on Monday this week, Monday the 11th of October. The problem about elevating Judge Zondo is that he only has 2.5 years to go. So this whole process will have to be repeated if he is made Chief Justice. It's a pity that he is so close to retirement, because having been Deputy Chief Justice is good preparation for the task of becoming Chief Justice. And he would clearly be a good Chief Justice and may even crack the nod, because he is probably the least controversial of all of the appointees. The fourth and last serious candidate for Chief Justice is Russell Madlanga, who is the last judge. Listen to this carefully and ponder it. He is the last judge in the Constitutional Court who has experience as a practitioner at a bar in South Africa. None of the others have ever practiced as an advocate. That's quite a fact to reflect on. Madlanga's problem is similar to that of Longer. He only has 3.5 years of his term of office in the Constitutional Court left, but that is a year more than Zondo, and he may be the dark horse in the race. But I think that it's really between the two judges president, who are Amaya from Bloemfontein, the Supreme Court of Appeal, and Malambo from the Gauteng High Court.
And when do we expect the appointment to be made?
How long is a piece of string? There's a long. The president is a known ditherer. He will dither on this like he dithers on everything else. So he ought to do it now, but he's already late. There is no Chief Justice, just an acting Chief Justice.
Well, these are extremely important questions for the future of the country. First of all, the accountability of our judiciary, and serious questions have been raised by this whole Hlophe business. And then secondly, the key role that the new Chief Justice will play in ensuring the continuation of a proper constitutional state. Paul, we'd like to thank you for participating in our discussion today, and we'd like to wish you every success in your efforts to achieve accountability in our society, now rather than in the future.
Thank you, Dave. Thank you for the opportunity.